we've filed, signed an acknowledgement, quote unquote, being served, do your financial disclosures, which are mandatory by both parties. It's called the preliminary declaration of disclosure. It's the income and expense declaration and schedule of assets and debts required that both parties do that in an amicable divorce. We're talking default with an agreement or uncontested, which is the way we handle the cases. In most cases, it's going to be default with agreement. You do the financial disclosures. The idea there is to get on the same page. Here's what we have. Maybe husband or wife did all the bills. Like in my family, I do all the bills. I do all the reconciliation. I do all the banking and all that. So maybe my spouse isn't aware, although she is, of all of the assets we have. Maybe I started a IRA on the side or a Roth IRA for my business or something like that. The disclosure process is to say, here's what I know that we have. And then they do the same. Here's what we know, what we have. And then we're like, oh, I didn't know you had that. Or you opened another bank account, or I didn't know you had this extra credit card. A lot of people, and it's one of the things we're going to talk about, is keep their assets completely separate. But we'll get into that in a minute here. And just a tip, if one of you takes the lead, and there's usually one person kind of leading the charge on the divorce. Maybe they're the one that had the consultation with me. Maybe they are spearheading this, and they're the one that wanted it, so they're moving it forward. And usually the other one may be a little reluctant, but not as much on the same page as wanting to as aggressively to get the paperwork and get through the process and get that done. In that case, one party can do the financial disclosure. You can do that schedule of assets and debts, list all the stuff. And then you can sit down with your spouse, and this is kind of like a pro tip, and say, hey, here's what I have. Is there anything we need to add? Am I missing something? Did I forget something? Do you have anything else you want to add that I'm not aware of? Just make it simple. You guys don't have to do it blindly. Like if you know, like if I knew everything and my spouse didn't, and I do this disclosure and I'm like, well, I'll wait for you to do yours. I mean, what's the point? Just make a copy of it and say, here, add it, and then do your disclosure. Make it simple, especially if it's an amicable divorce. I know when I worked for a law firm 13 years ago, the trick was, wait for the other party to do their disclosures. And once you had them, is you just basically make a copy of them and then show your client, hey, this is what they add. What do we have to add? That's it. Doesn't have to be super complicated. Once the disclosures are done, then you can reach your settlement agreement. And now you know what all the purpose of that is. Now you know what everything's on the table. And now you can come and start working towards an agreement and start drafting up the settlement agreement. It's called the judgment package. There's some other procedural documentation that goes along with that. And then you guys sign that, notarize that, and that's what gets submitted to the court. And that's what becomes your divorce decree.